Good morning, everyone. This is Ellen Shemitz from Connecticut Voices for Children, and I want to thank you all for joining us for this webinar, which is looking at equitable education in the state and particularly looking at the impact of the rulings of the CJEF opinion. The reason we're offering this webinar is because of the concern that some of the media coverage has not given a full picture of the court's decision. A lot of the media focus has been on what's characterized, in some cases very appropriately, as a call for sweeping reform, but less attention has been paid to some of the more troubling legal aspects of the case, as well as some of the more troubling educational policy implications. Now, just a few housekeeping measures. This is our first time using the YouTube for a webinar, so we hope you'll bear with us as we make sure that everything is moving smoothly. But for those of you who haven't used the YouTube webinar before, there is the opportunity to type in questions. On the right-hand side of your screen, you'll see a message bar. And if you type in those questions, our plan is to try to address as many of them as possible towards the end of the presentation. So with that, let me just give you an overview of what we're going to be covering today. As I said, we're calling the presentation The Good, the Bad, and the Ugly, or actually The Good, the Bad, the Surprising, and the Ugly, a little bit of a modification of the Hollywood version. We're going to begin today with a discussion of some background, the the source of the right to public education, and a little bit of legal history about CJEF. We're then going to go into the good part of the opinion, specifically the state duty to educate, the strong mandate that local control does not pose any defense or does not in any way undermine the state obligation or responsibility, and then some really important findings of fact. We're then going to talk about the bad, the legal standard that was articulated, and the lack of a finding of a violation of equal protection. We're going to go to the surprising, which is some of the education policy mandates that were handed down, and then talk about the ugly, which is the court's language around special education. And finally, we're going to move to looking ahead, just talk about the status on appeal and some of the next steps that we see from an advocacy student-centered perspective. So we'll begin, as I said, with the background. I expect that most of you know that the right to education is a matter of state law, and it's grounded in the state constitutional amendment, which was enacted at the Constitutional Convention in 1965. The constitutional provision reads in Article 8, Section 1, there shall always be free public elementary and secondary schools in the state. The General Assembly shall implement this principle by appropriate legislation. The reason this is a matter of state law and state constitutions is because back in 1973, the U.S. Supreme Court held in the San Antonio Independent School District versus Rodriguez that the U.S. Constitution itself doesn't provide a substantive fundamental right to education. So all of the education lawsuits that have gone forward across the country have been grounded in their state constitutions. And those education lawsuits that have been taking place for the past 40 years or so have been of two different types. They focused on equity and they focused on adequacy. In Connecticut, the first education lawsuit was on equity, and that was the Horton versus Meskill decision that came down in 1977. And Horton is obviously an important decision because it identified the right to education as, quote, basic and fundamental, which means that any alleged infringement of that right would have to be strictly scrutinized by the court. And it defined that right to education as the state obligation to provide a substantially equal educational opportunity to its youth in its free public and elementary schools. The key points under Horton are really can be identified as three. One, that the right to education is fundamental. Two, that the state has to provide this substantially equal education. And then three, it's finding in the Horton case that the education formula then in place did which a formula which provided the same amount per capita regardless of local resources or student need, that formula itself was unconstitutional. And in the wake of the Horton decision, the General Assembly came forward with the definition of public education. First, a definition that was that provided the same amount per pupil, regardless of student need or regardless of the local property wealth. That formula was then replaced with ECS, which more or less has continued to this date. So let me move forward a little bit to CCJEF and the procedural history of CCJEF. CCJEF case was filed in 2005, and the plaintiffs were basically contesting the adequacy of the overall state funding, whether or not that funding was sufficient to ensure what they were calling a right to a suitable and substantially equal educational opportunity. And they had two core components to their argument. One, that under the definition of the right to education as set forth in the constitutional amendment and as validated by Horton, that the state had to provide more than a basic education. It had to provide something that was suitable, substantially equal, and it had to be funded in a way that was both adequate and equitable. The defense demurred from that. The state said that there was no such substantive guarantee, and that there was no right to suitable education, nor was there any guarantee of parity of educational outcomes, achievements, results. Initially, the trial court agreed with the defense. They dismissed 3 of the 4 claims, and that sent the case up on emergency appeal to the Connecticut Supreme Court. The Supreme Court rendered its decision, and the prime finding of that case in 2010 was that the Connecticut Constitution does guarantee a minimum substantive standard, a minimum qualitative standard, which did have to provide students with suitable educational opportunities, as the plaintiff had argued. But what's really important to know is that in that 2010 opinion, the majority opinion did not have 4 votes. It actually had only 3 votes. And that opinion, with the 3 votes, talked about 3 specific qualities of an adequate education. They said that the Constitution guaranteed that public school students would have the educational standards and resources suitable to participate in democratic institutions, that's 1, to prepare them to attain productive employment, 2, or otherwise contribute to the state economy, which is the 2nd, and then the 3rd one, or to progress on to higher education. That very detailed definition and that broad scope of the right to educational opportunity had the 3 votes. To get to a majority opinion, there was a concurring opinion by Justice Palmer, which got them to 4. And Justice Palmer's opinion was much more constrained. It said that actually the General Assembly is entitled to considerable deference in implementing an adequate education, and that the requirement of the constitutional amendment was only that the state provide what he called a minimally adequate education system. Based on the 4 votes between the plurality opinion and Justice Palmer's concurrence, the Supreme Court sent the case back to the trial court to determine if the resources allocated by the state were sufficient to meet the standard. So it went back down to the Superior Court, with the plaintiffs focusing on the plurality opinion and the defense, the state, focusing on the concurring opinion. There was a 60-day trial. It took place over 6 months. There were over 5,000 exhibits. There were over 58 witnesses. And then, of course, the decision came down in earlier last month and got extensive publicity, not only in the state, but across the country. And there's good reason for that. It is a broad decision, and it's been called landmark by many, including Alex Knopp, who's a professor at the Yale Law School and who is the head of the Education Adequacy Clinic. The essence of the case can be summarized in the quote that the judge pulled from Abigail Adams, that learning is not attained by chance. The idea is that the state has an affirmative responsibility to distribute funding in a way that is rationally related to the needs of the community and the needs of the student. So what's good in the opinion? There are really 3 components that are good. First of all, the court affirmed that children do have a constitutional right, constitutional guarantee for fair opportunity to elementary and secondary education. And the court was very clear that, in the words of Abigail Adams, that the state could not leave that learning to chance. Rather, the court said that the state must deploy in its schools resources and standards that are, and these three words are critical, rationally, substantially, and verifiably connected to teaching children. The court went on to say that this is not a lot to ask, but found that it does raise doubts about many of our state's key education policies. The second good part of the opinion from our perspective is the court's very strong language about the state responsibility not being delegable. In other words, the court recognized that Connecticut has a long history of local control, and he recognized that local control can have many positive values. But he said the reality of local control does not in any way relieve the state of its obligations to ensure that the fundamental right to education is protected. And in the words of the court, he said, it is obvious that local control can be a good thing. Knowing this takes nothing away from insisting that where great problems persist, great efforts may be required. The state may not have to rush to interfere in most schools, but when it needs to interfere, the state should not be able to claim that it is powerless. If the state is not giving children a constitutionally required fair chance in school, it may not use its own laws as an excuse. And given the importance and the power of local control in the state, the court's insistence that the fundamental responsibility lays with the state is quite important. And finally, in terms of the good, we think that one of the real benefits of the state, of the opinion, is that it provides in one place, it compiles in one place a lot of the evidence brought forward at trial about the tremendous disparity in well-being, disparity in outcomes that exist between different school districts across the state. The court found that the distance between the outcomes, the results for rich and poor students in the state is, quote, great enough to remove any doubt about the importance of being careful to send money where it is most needed. The court compiles a lot of, hundreds upon hundreds upon hundreds, I think almost 1,000 findings of fact that have to do with specific disparity in outcomes. Among some of the findings, the court points to the fact that in the richest communities, more than 70% of students meet third grade reading goals. He contrasts that with the fact that 70% of students in the least affluent communities did not meet those same goals. He looks at the math goals as well. And whereas about 90% of students in the richest communities met third grade math goals, the majority of students in the poorest communities did not. And so bringing together all of those findings of fact and having them in one place is very important in terms of the advocacy community's ability to take these facts out to the public and to increase public understanding of the vast disparity in opportunity and how where you live can have such a dramatic impact on the likelihood of your having an opportunity to achieve your full potential. So much for the good. We want to go on to what we call the bad of the CJEF opinion. And we want to focus in this case on the legal standards. Despite the excitement over what Attorney Knopp rightly called a landmark case, the fact is that the trial court really pushed back from the broad language of that plurality opinion and the three outcome standards that were articulated in the plurality opinion. Remember, the plurality talked about the education being sufficient to ensure the ability to participate in democracy, the ability to contribute to work and the economy, the ability to go on to higher education. What the trial court found was that he felt that he was bound by what he called the more restrained approach that Justice Palmer articulated in the concurring opinion. And the trial court said the most the four justices agreed on was that irrational public school resources and standards are unconstitutional. And under that much lesser standard, he found that the plaintiffs failed to show that there was an adequate state funding. He said that they had not proven, and this is the standard he looked at, that the state schools lack enough light, space, heat, and air to permit children to learn. It is that very low standard, something that he pulled from a related New York case, that causes some real concern in terms of the scope of the right to education and how it will be interpreted. And it's worth noting that Judge McCousher's interpretation, both of Justice Palmer's concurrence and of the New York case, is contested by plaintiffs. Again, what Justice McCousher found was that the legislature must spend at least enough to create things recognizable under contemporary standards as schools, not a broad or very deep obligation. Because it has done so, the judge found the state has not violated the Constitution by devoting an overall inadequate level of resources to the schools. So the judge found that from an adequacy perspective, the funding was adequate. He then went on to look at whether the distribution of the funding caused concerns. And what the judge said is that the violation of school aid did give more money to poor towns than to wealthy ones. He specifically noted that more than $400 million has flowed to the 30 lowest performing schools since 2012. He noted that in 2015, 13 million went to the commissioner's network of 14 failing schools, another 4 million in school improvement grants to 30 high need schools. And he said that the current education spending disparity favored the impoverished school districts. And as a result, he said, they can hardly claim that getting more money compared to other schools is the cause of their woes. He said that under a equal protection analysis, the fact that the poorer towns received more money than the wealthy towns was fatal to their equal protection claim, and found that there was no violation of equal protection. So those are the two bad findings. The amount of money was adequate, and the distribution didn't violate equal protection. But that wasn't the end of the story, and that's why we call what happens next the surprising part of the story. And some of what I'm going to talk about may feel like a non sequitur, because the court found that even though the distribution didn't satisfy the heightened standard of equal protection, it did satisfy a lower standard of what he called rationality. He found that the state had failed to meet minimal standards of rationality in the area of funding, in the area of graduation standards, in the area of teacher evaluations, and in the area of special education funding. So let's first talk about special education funding. Key to the opinion, we believe, is likely the court's frustration with what happened in the spring of 2016, when the judge was already likely beginning to form some of his conclusions during the trial. And in the spring of 2016, the legislature manipulated the ECS formula, stepped away from the ECS formula in order to reduce aid to 14 of the state's poorest towns by over 5 million, 5.3 million. And it increased ECS aid to 22 relatively wealthy towns and increased that by about 5.1 million. The judge found that the court disagreed with the state's argument that that $5 million was not a large amount. He said that that $5 million could pay for approximately 59 full-time teachers for a year, which he noted would be a significant amount to struggling districts. And the court noted, quote, "This broadcasts that the legislature does not feel bound to a principled division of education aid. If this view of the state's constitution won out, the legislature would be free to make today's 5 million, tomorrow's 50 million, and the next day's 500 million." He said that a plan that spends a lot of money and is not entirely irrational is still not a rational plan, but that by cutting towns for some wealthy districts, well, without formula or explanation, the state also protected education aid for other comparatively wealthy towns. And that caused him to find that the school funding formula was irrational. He said that an approach that allows rich schools to raid money desperately needed by poor towns makes a mockery of the state's constitutional duty to provide adequate educational opportunities to the students. He ordered that within the next 180 days, the state craft a new education formula that would address education aid as well as school construction. What the court found with respect to the graduation standards was that what it means to have a secondary education, the court said, is like a sugar cube boat. It dissolves before it's half launched. The court went on to quote the poor outcomes for a number of impoverished students and students who enrolled in the community college level, noting that the statistics forced the conclusion that the state's high schools are graduating students unprepared for higher education. The court noted that you can't overlook the failure of our graduation standards in poor towns when a solid majority of their students are graduating unready and a solid majority of students in rich towns aren't having any trouble whatsoever. He came to many of the, he ordered that the lack of rational graduation standards breaks the state's constitutional promise of a free secondary education by making it for the neediest students meaningless, and gave the state 180 days to craft new graduation standards. He did much the same with respect to teacher evaluation and compensation, making findings and rulings about education policy which raise a number of troubling issues from a policy perspective, but which we're not going to address in full now because we're really focused on the legal implications. But what the court did find is that the teacher evaluation is almost entirely local and the standards are almost entirely illusory. He rejected the state defense of the power of local control, saying if the system was set up by the state, then the state is responsible for the system. And he said, using another flowery analogy, that the state's teacher evaluation system is little more than cotton candy in a rainstorm. Good teachers can't be recognized and bad teachers reformed or removed. The problem is that the court made a number of findings and rulings with respect to suggesting what the General Assembly should do. A lot of support for high stakes testing, a lot of support for direct linking of student outcomes to teacher compensation and evaluation. And yet there are a number of concerns in the literature and best practice as to whether or not that would be good policy, let alone constitutionally required. That leads us to what we call the ugly of the opinion, which is the special education part of the opinion. As an attorney who represented children and families with special needs for over a decade up in New Hampshire, I find this part of the decision most definitely troubling. The state raised two concerns. The state challenged whether or not the cost of special education for those with multiple disabilities, the funding at the level that it's currently funding, was really necessary. And the court further challenged what he called the arbitrary nature of who was identified for special education. The court questioned whether or not there really needed to be the full scope of services provided to children with multiple disabilities, saying that schools shouldn't be forced to spend their education budgets on other social needs, however laudable, at the expense of special education students who can learn and all the other students who can learn along with them, and actually dismissed the affirmative obligation of the state to children with multiple disabilities as, quote, urban legends about the IDEA, the Individual with Disabilities Education Act. I have to agree with the Attorney General, who, in his appeal of this decision to the Supreme Court, stated that setting standards to deny special education services to students who are too disabled to benefit educationally would almost certainly violate federal law. So we have the good, the bad, the surprising, and the ugly. We want to take a moment to look ahead, and then there are a number of questions, and I want to see if we can get to those. So first, what the court ordered. The court ordered very broadly that change must come and that it was a duty of the General Assembly to craft remedies that would address the education aid formula, that would provide a definition of elementary and secondary education, that would provide standards for hiring, firing, evaluating, and paying education professionals, and that would set standards for funding, identification, and services for special education. Now, as you know, when the court said that the state has to accept that the schools are its blessing and its burden, and if it cannot be wise, it must at least be sensible. As you know, the case has been appealed. The Attorney General has argued that once the court found, as we noted at the outset, that there was no constitutional violation based on the amount of the funding and no constitutional violation based on the distribution of the funding, that it should have gone no further and it shouldn't have made its broad sweeping rulings with respect to education policy. The plaintiffs, conversely, have argued that while the court correctly found that the distribution of aid was not rational, it erred in the other three areas we pointed out, that it applied the wrong standard to determine adequacy, a standard of rationality, that applied the wrong standard of proof, requiring proof beyond a reasonable doubt, and that it erred by dismissing the equal protection claim. And all of the briefs and the cross briefs will all have to be filed by April 12th of next year. So there's going to be some time before we even get to oral argument on this case. Meanwhile, these issues are now squarely before the legislature, and we believe and hope that the legislature will pick up a responsibility to address some of the questions, particularly the questions about the disparity in outcomes and the disparity in opportunities between schools, between wealthy towns and poor towns. And indeed, the Attorney General encouraged the General Assembly to do just that, saying that the case addressed profound educational challenges, and there's nothing in the appeal that would prevent the legislature from taking up those challenges now. So too, Governor Malloy said that it would be prudent to address the systemic problems in our educational system, particularly fair funding, in a serious manner, once and for all in the 2017 legislative session. With that in mind, we think it's important that the legislature pay some attention to some of the dicta in the court opinion. Again, this was the court talking about education policy, so it did not include it in its ruling, but it did emphasize the importance of early intervention. It did talk about the need to focus resources on our poorest districts. And it did talk about the importance of the role of high quality preschool, again, saying that it was important as a policy matter, albeit not constitutionally required. We believe that these observations by the court, together with the findings of fact about the dramatic disparities in opportunity, create an opportunity for the legislature itself to take the initiative in reforming the amount and the distribution of school aid to raise the level of public education for all students. We believe that the court's rejection of local control as a defense provides an opportunity to take on these issues of inter-district disparity, even in some cases intra-district disparity, and to engage in meaningful conversations about property tax reform and about regionalism. We also think that the court's focus on early intervention and the importance of early childhood education provide an opportunity to address the unmet need for quality early care and education in some of our poorest towns and cities, indeed across the state. And we think that the court's concern about standards for teacher evaluation and compensation provide an opportunity to look at some of the best practice policies and research about how to create a system that values teachers as professionals and to recruit and retain the most talented individuals. So that constitutes the scope of what's happened in, from our perspective. I want to take a moment to quickly look through some of these questions and try to answer them in real time. One of the questions was, what's the best place to access the facts that we spoke about? If you go onto the court website, you can get a PDF of the entire court opinion, and that opinion contains an appendix, which is all of the findings of fact. And the findings of fact go into great detail on test scores looking at outcomes in a number of districts, primarily contrasting wealthy school districts and poorer school districts. Let's see, other questions. It looks like most of the rest of the questions had to do with problems with actually hearing the presentation, which I think hopefully we resolved. So I don't actually see other substantive questions. Oops, one more just came in, and it is, what was discussed by the court? 1 second. Yeah, one commenter simply mentioned that was discussed by the court was actually based on the original ECS formula, whereas that formula actually hasn't been fully implemented for a number of years. That's certainly true that it hasn't been implemented, and that's part of what got to the court quite clearly. The court was really annoyed that there was a departure from the ECS formula, and that departure was impossible to justify in terms of the standard of rationality. And part of what really annoyed the court was that the departure that took place last year could take place in future years in even greater lack of rationality, and that there was a need for a standard that was verifiable and that to which the state would be held accountable. And then there is a question about whether or not the role of property taxes in educational disparities, whether that was identified or addressed by the court. And the answer is yes. The court spoke very specifically about the disparity in the ability of towns with a less rich resource base to fully meet the needs of their children, and drew a direct line between the issue of property wealth and student opportunity. And that again opens up the door for the legislature this term to look at the question of how we're funding our schools broadly and whether or not there needs to be reform. Indeed, Connecticut Voices for Children is doing some work on different property tax reforms, looking at work that's been done in other states and modeling what implementation of some of those reforms would look like here in Connecticut. The court, then there was a question about whether or not this presentation will be available here on YouTube. The answer is yes, the presentation will be available. There will be a link from our website and you can download the presentation. And then finally, there's a question about, did the court discuss resources for English language learners? And actually, I don't believe that it did. I'm looking to my colleague in the room for affirmation, and he agrees with me that no, that was not brought up. And finally, there's a question, can you comment some more on what's meant by the arbitrary nature of who is identified for special education? What the court said, what the court noted, was that there seemed to be no consistency between school districts as to the practice of identifying students under the IDEA, and that there seemed to be, in his opinion, an over-identification of students in some towns and arguably an under-identification in other towns. And again, he said it's that lack of predictability between districts which failed his test of rationality and predictability. And I believe that seems to have addressed everyone's questions. I want to thank everyone very much for tuning in, and we'll be happy to answer any questions offline or make this presentation available if people have trouble accessing it. Thanks so much and have a great afternoon.